Hello, I'm Robin Jackson and welcome to this Legal Sector Roundtable from Nuance Communications in partnership with LexisNexis on giving justice a voice. The Supreme Court has certainly taken the lead on digitising its business. The business and property courts were able to conduct about 80% of their cases through remote hearings during the pandemic. And the roles building was understandably constructed with excellent tech facilities. And commercial matters are now generally run between the court and various participants using commercial case management software. The court estate in general, though, has been renowned for its old buildings, outdated IT equipment, and poor internet access. Part of Her Majesty's Court and Tribunal Services reform programme is the Common Platform. Rather long in its gestation, it must be said, it's now in phase 1 of its rollout in the Magistrates and the Crown Court for criminal case management. It's now live in over 100 courts, with rollout due to be complete by March next year. I'm not sure, though, on how common HMCTS thinks that the Common Platform might become across parts of the justice system other than crime. The Cloud Video Platform, CVP, linking all participants in a remote or hybrid hearing, is the video system of choice of HMCTS, which came out of the Common Platform programme. It's used in many civil and family cases, as well as criminal hearings. But, I understand, the choice of platform lies with the judge, and many prefer other ones that are available on the market. The digitisation of justice has been spurred on by the COVID-19 pandemic, but of course, it all started when a lawyer, or their assistant probably, began using a word processor rather than a typewriter or even a fountain pen, and then a photocopier, learning from businesses in other sectors which were already doing this. Digitisation goes way beyond case management and video systems. It starts in the production of documents, the filling in and submission of forms, the exchange of information at all stages of the development of a legal matter, within a firm, a police station, the probation service, with an individual barrister or solicitor or even social worker, and then between them all. And it goes beyond improving the efficiency of document handling and process management in the justice system. Operational matters such as storage needs, archiving, compliance with data protection regulation are all significantly impacted by digitisation or indeed the lack of it. So I'm delighted to be joined by a great panel of experts to look at the digital transformation of workflow across the justice system. These are Richard Atkins Qc, a renowned criminal silk who's the head of St Philip's Chambers in Birmingham, a Crown Court recorder, and was formerly the chair of the Bar of England and Wales. Jonathan Silverman is a commercial lawyer who founded and ran his own law firm, which he then successfully merged with a national firm. Jonathan now runs his own consultancy, Silverman Advisory. He's a recognised industry leader, commentator, and university lecturer. Stuart McMillan is a policy analyst at the Bar Council and focuses on aspects of legal technology and AI. He also works with HMCTS on their court reform programme and writes on developments in the legal services sector, particularly regarding legal tech. Vladimir Teodosiev is a senior manager at Nuance Communications, developing and delivering best practice solutions for businesses in both the public and commercial sectors. And Simon Howard from Crescendo Systems is an expert in speech recognition systems whose work has brought transformational benefit across organisations in private healthcare and the NHS, as well as businesses in the legal and other professional services sectors. So welcome to our panellists. Let's start with how we got to where we are at the moment. Jonathan, what's been your experience of the business-led move towards digitisation of processes in the legal sector as a whole over recent years?
I think you summed it up by saying it is business-led. It's not that the practitioners decided that they want to digitalise, it's that they had to do it because the clients demanded it perfectly reasonably. The professionals tends to be fairly cautious about any sort of change, but the reality is that digitalisation has just taken place and lawyers have got to move with the times in that way. I mean, gone is the day when I remember a US client coming into the office and saying, "Can I plug into your system?" And the lawyer pointed to a 3-pin plug. It has moved on somewhat since then, but it is very much the fact is that you've got to lawyers recognize now that it's the clients who drive the matter. Lawyers are the servants rather than the masters in the 21st century. So it's the ability for clients to be able to use law firms which has led to the changes. And those changes have been quite widespread.
Jonathan, thanks. Richard, how have you seen this in the world of barristers' chambers?
Chambers have had to upgrade their IT capabilities. In my chambers, St Philip's, certainly in the criminal world, I'm a criminal silk, briefs arriving, multiple boxes, pink ribbon flying all over the place is pretty much gone. I feel rather sad for the pink ribbon producers. It's all digital. We had a huge brief library that's been ripped out. The Chambers director has a nice swanky new room. There were downsides. I suspect we'll touch on those in a while. People don't have to come into chambers any longer because things are digital, but there are upsides. If I've forgotten to leave a brief in chambers, I don't have to drive halfway across the county to deliver it to a colleague. People are investing more. Most barristers, I think, have had to upgrade the technology they use. In my chambers, we've upgraded our conference facilities. We have video capability in almost every conference room now to allow conferences with clients, logging into courts, conferences with prisons. I suppose it's cut down a huge amount of photocopying and a huge amount of, as I say, storage space. So yes, there's been quite a lot of change.
Vlad and then Simon, maybe, how have you seen the legal sector interact with the tech sector in embracing digitization?
Thank you, Robin. I personally feel that many have adapted well to the accelerated digitization. Luckily, most organizations actually within the legal sector have at some moment in time completed or worked on a digital transformation program to boost efficiency that includes the adoption of technology. However, more remains to be done. I feel that one key area to remember is that technology needs to be viewed in conjunction with process and people. And most importantly, choosing the right technology for the right use case and process, as well as delivering the change management program effectively, remains a vital component to any initiative.
Thanks, Vlad. Well, partly driven, I think, by the government's digital by default directive to drive paperless efficiency across the country's judiciary. It's been very clear to us that firms recognise the need to reduce their dependency on paper. And they've embraced technology in many forms: CRMs, document management systems, cloud and mobile technologies. Certainly in terms of speech recognition, law firms have, of course, been employing digital dictation systems for a considerable time to speed up the documentation process. For me, speech recognition, now that it's mature, it's easy to deploy, it's accurate, and it's easy to use, really is the next logical step for lawyers and the judicial system in general, in order to incorporate into their systems and their workflow.
Thanks, Simon. I think one thing that I pick out of that I've also noticed in other discussions that have happened, especially over the last year, is where does IT, where does technology sit, or where does technology leadership sit within the organization? Whether that's a law firm, a set of chambers, the court, HMCTS, or whatever, is who within the management of your organization leads on technology. And if you don't have someone who's on the board table doing that, then actually technology is just another one of the facilities that the organization has. Maybe we can pick up on that later on. Let's look now at the ongoing court reform program and the greater impetus for digitization caused by the pandemic. and specifically the introduction of the common platform for criminal justice. Richard, what's been your experience of the common platform as both a barrister and a judge?
As yet, the common platform hasn't been rolled out completely. It's been promised for a long time, but it is now being rolled out to some courts. I haven't actually experienced it in any of the courts I've sat in or appeared before at the moment. But in the criminal courts, we've been using the digital case system, which is all part and parcel of it for some years. So, as I've already mentioned, paper has pretty much disappeared. There's been a lot of training given to the judiciary and the bar as to how to use the various systems that are in place now. I think COVID has pushed it forward. Prior to COVID hitting, I think I'd done a couple of hearings by telephone and the odd link in occasionally, but we've had to grasp it with both hands in the criminal world. It doesn't work for jury trials, although we've been able to have witnesses linked in to trials, which is becoming more frequent. And it's also now being used widely by advocates linking in to deal with short hearings digitally, rather than having to spend 3 hours traveling to get somewhere. You walk 5 minutes to your study and can get on and do the job. So it's been embraced. It's been forced on everybody, but it seems to be working. I think the downside for the judges is that in the past, the listing officer would look at a pile of paper and say, well, there's too much there for a judge tomorrow. Now they can assign cases, and of course, it's only when you open it up. I've had experience myself with the listing officer saying, oh, it's only a short case. But when you actually open it and look at it, it's anything but short. But on the whole, I think it's working pretty well. It needs investment. We'll see how much investment it gets, but I'm a fan.
That's great to hear. Yes, you can't tell how many pages are in it just by the number of bytes that make up the document. Stuart, with your insight into the HNCTS and also the Bar Council, how have you seen the success of the common platform?
Well, I think, Robin, the common platform is one part of a much larger puzzle, as I think Richard alluded to. And I think the digitization program as a whole has had many successes. Particularly, I think the rapid rollout of the cloud video platform, which is the system used for online justice, which was meant to be rolled out over sort of last year and this year, and had to be rolled out within a matter of weeks as COVID hit. But I think sort of a wider issue here is the kind of multifaceted nature of the program, and as Richard alluded to, there's the less pink ribbon element, which is the paperless element, and modernizing some rather kind of antiquated procedures, which I think has gone fairly well. But then there's also the aspect of what I think Jonathan touched on, things like interoperability, and making sure that all systems speak to each other. And I as I understand it, that is the aim with things like Common Platform and My HNCTS. But I think there's probably a bit more work to be done there. And I agree with the point about investment. I think there's plenty of money been spent on this already, but there's probably more needed if we all want the court system to get to where it needs to be to function in 2021.
Are we seeing now lawyers and their law firms or chambers sort of collectively, fervently taking up digitization? You talk about it takes more money. That in many cases is going to come from the law firms and the chambers. Do you think there's the appetite for that? Jonathan, how about you first?
Partnerships are a dreadful vehicle for driving firms to invest in anything, but leaving that to one side, I think there's a reality, which is when people start seeing a return on digitalization, they recognize how incredible it can be. I've got one firm, for example, who do a lot of criminal work. Over 30% of their work now comes over the web. They have a very good website and it's very accessible. Another firm who do a lot of matrimonial work find that a huge number of their instructions come late at night from people going online and typing things in, probably once their spouse is retired for the night. So as soon as you can show that there's a direct link between making that investment, taking the leap, using digitalization, you recognize that it's actually going to improve your profitability. It's also going to improve your ability to deliver properly to work to clients. You've got things like PLC now is a standard precedent system. There was a time when every law firm had their own precedents, and when you started a document, which came in from another side, a lot of work to do. Now you know where you're starting from. Digitalization is going to move forward, and I think you're going to see law firms adopting far more software which will enable them to do comparisons between documents. And then, of course, we have AI floating around, and that's going to make a lot of difference to the way in which lawyers work.
Indeed, and the AI question is something for a far bigger webinar than this one, probably. But we are already seeing, especially in the realms of disclosure, the use of technology to significantly speed up and reduce the costs on law firms in particular. Stuart, are you seeing investment in places like the Bar Council and the specialist bar associations, let's say, in both in their own technology, but also in promoting technology across the bar?
Well, I'm not sure I could speak for the SBAs, but definitely I think barristers, and Richard will probably have a view on this as well, but I think to a certain extent they've had no choice with COVID, particularly last year. If they wanted to work at all, then they had to invest in at least the basic tech. I think some chambers have grasped the nettle more than others, and that's for various factors. That's not a sort of a slight. I think some were probably a bit better equipped for it than others, and some have got a longer way to go. But I think where it's slightly different is in the kind of finer detail. And it's one thing to sort of, from an organizational operational perspective, we're going to invest in X, Y, and Z, which I think a lot of chambers are doing. But there are also things like, for example, bundles and e-bundles, where the Supreme Court has a protocol on electronic bundles. But I think old habits die hard, I guess, and there's that aspect of kind of investment and promotion is one half of it, and then the profession being kind of willing to buy into it is another. And I think it's getting there, but there's probably still a way to go in certain areas.
Thanks. Yeah, certainly in my experience, you can't judge the likelihood of someone wanting to take up digitization simply by their age or experience. There are youngsters as well as perhaps the older members who are quite reluctant in some cases. But I expect that, as we've all said, COVID has been a bit of a prompt for them. Richard, Jonathan said that a partnership was a dreadful model for financial investment. What's your take on the sort of the normal chambers model, and how do you think that, looking at the court side, are judges and court staff sort of badgering for investment in tech?
I smiled when Jonathan mentioned the partnership. I was going to say try running a a business that's 136 individual self-employed practitioners. Just before I answer your question, picking up on something Stuart said, I think the bar has pretty much had it forced upon it. If you want to work, certainly in the criminal courts, you have to be au fait with tech, IT, because you can't get your briefs unless you are able to use your computer. Things are now sent, whereas we used to have videos with DVDs, it's all in the cloud now. So people have had to really grasp this, and some struggle. I think one of the problems is I'm an Apple user. I suppose I have to say other products are available, but Apple does tend to have problems. They seem to concentrate on non-Apple, and it doesn't always work with Apple. And I think that's something that really must be grappled with, because if you are a MacBook user, why should you be at a disadvantage? As far as the courts are concerned, I think that I'm not sure that people are necessarily sort of clamoring. I think what they would say is, if we have to use a system, can we have a system that works? Because things have crashed. When we went into lockdown, I was sitting on, I'd sworn a jury on the Monday evening, the last thing I'd done, and on the Tuesday I discharged them and sent them home. And then we had to work out how we were going to run the court that I was sitting in for the rest of the week. And I used Zoom on the first morning before being told you can't use that. It's not secure enough, which struck me as rather odd, because we would have been in open court. But we then had to use everything we could. There were telephones being used, Teams, Skype, whatever, and we all had to dive in. And I think the court staff would say, we don't mind what you use as long as it works. The judges won't have an opinion, because they will use what they're given, I suspect. But I think we've all had the experience of using platforms that we like, whereas we're told, well, you can't use that, you have to use something else. And they need to make sure that the platforms that we are using are they function well. I think that would really be the cry from the bench and the court staff. It's down to investment, as I said earlier.
Thanks, Richard. I think what we're one of the real challenges going forward is that we've seen all sorts of things come in during the pandemic, but actually it is achieving now that commonality, so that both within sectors of the justice system, but also across it as a whole, people will know what platforms they're going to be using for what. It's not helpful, especially if you're in a multi-practice law firm or set of chambers, having a variety of different platforms or applications that you're going to be using, or indeed even in single practice area firms and sets, where you will have different courts deciding on using different platforms for video, for example. Vlad and Simon, what are we seeing in other services associated with the justice system, the sort of police, probation, health and social services, for example, in the way of embracing technology that is compliant with what the rest of the justice system is doing?
Thank you, Robin. Well, I think it's fair to say that in all document heavy services and professions, they can all benefit from deploying speech recognition, and in so many ways. In the police service, for example, there are opportunities for both station-based and field reporting scenarios to reduce the administrative burden and in turn free up more time for officers to police our streets. In fact, just this year, the National Policing Digital Strategy for 2020 to 30 was set out, and within that it contained a brief full of digital ambition for the service to be able to leverage these technologies and build capability. As far as the probation service is concerned, well, obviously that relies very much on the production of lengthy reports and assessments. And that's something that speech recognition can really help with to speed up and streamline the processes. But for us, I think perhaps the sector that has leveraged and benefited most from the technology to date would be healthcare. And with the centralization of key clinical, hospital, patient systems and the creation of its own common platform to share information securely in the form of the NHS spine and electronic patient records, speech recognition has become an increasingly deployed software tool in the clinical documentation process. At the end of the day, faster, more accurate clinical reporting can lead to better patient outcomes. And that, alongside the pressure of staffing and finance in the NHS, has been a key driver to its adoption. I'm sure we'll see something similar occurring within the justice system and its own common platform.
Vlad, have you got anything to add to that on what we're seeing in other services associated with the justice system?
Absolutely. Thank you, Robin. I think we need to remember as well that we entered in this pandemic on the back of a pretty long austerity period as well. And this has certainly tested the resilience of the police, probation, health and social services, and in many cases has actually pushed some of these organizations to their limits. I think one key finding by interacting with these organizations is that obviously adopting technology, and I think Simon has been speaking about speech recognition as a specific type of technology that can help, is actually absolutely critical to providing a more fairer and effective justice system, as well as the much needed health and social services in certain areas. So absolutely, I think creating accurate and detailed documentation in a timely manner is extremely vital in that respect. And to concur to what some of the things that Richard and Stuart have mentioned as well, I think a bit more investment is needed in these areas to help organizations adopt these technologies and alleviate some of these stress areas and eliminate some of these problems that have been compounding for many years in some cases.
Thanks, Vlad. Picking up on another thing that Richard mentioned about the fact of deciding to use one platform and then being told, no, you can't, you've got to use another. I think that's symptomatic of all forms of crises, when all of a sudden you get all sorts of so-called experts coming out of the woodwork who are saying, no, you can't use this because it's not secure or because of this, that, the other, normally based on certainly outdated information, without being aware of how the technology has developed over the years since they heard that piece of information. And so we've now seen sort of Zoom go out, Zoom come back in. We've seen Skype for Business be in, Skype for Business be out. Again, that's the whole idea of the commonality, as well as searching for commonality. How does the justice system get accurate information on what is permissible and what isn't? It's sort of like asking the ICO, what's the best advice for data protection? They won't actually give you that advice. They'll just point you in the direction of a regulation. Okay, let's look at some of the more sort of human aspects and impacts of digitization, because digitization is often seen as potentially an enormous benefit to enable access to justice, but it must also comprise disadvantages. From the perspectives of access to justice, equality and diversity, what do you think are the advantages to be gained from digitization and the potential disadvantages to overcome? Stuart, do you want to take us off on this, and then Jonathan, and then Richard?
Sure, thanks, Robin. I think the advantages are obviously the flexibility. I think Richard mentioned that means that counsel don't have to go up and down the country for short administrative hearings and such like, which is a big benefit, I think, to everybody in terms of time, in terms of efficiency, and that's the same for the client. They don't have to make those long journeys. I mean, there've been a lot of court closures over the past 10 years. And getting to local court may take longer than maybe it used to over a decade ago. Obviously, the flip side of that coin is that you need the tech to do it. Even as simply as having a laptop and a good internet connection. And I think the phrase that's been coined is the digital divide, which has been mentioned in a lot of articles and academic studies. And sort of between those who have the access to resources and those who don't, and there are still a significant number of people in this country who don't have access to basic tech, and particularly in if I can put it, outside of the roles building, in other courts, there will be clients that may be dialing in on their phones, have limited data, and everything that goes with that. So I think that's the other side of that coin. I think the other thing that I would say is that, and Richard can probably talk more about this, but particularly in criminal and all sensitive and complex matters, it's very different. It's a very different kettle of fish doing it online, and particularly with things like jury trials, which have been tried remotely in Scotland, but not so much in England and Wales. I think because a lot of the conversation has been around, well, how do you assess body language? How do you kind of, sort of look your jurors in the eye if you're on Teams or Zoom? And I think that's a massive, or one of the biggest elements of the access to justice and fairness conversation around digitization at the moment, in that as brilliant as all of this remote stuff is, we need to make sure that it doesn't kind of diminish the justice process, basically.
Thanks, Jonathan.
My thoughts on this one is quite interesting, on the concept of access to justice and diversity. Two sides, it's two ends of the telescope. From the lawyer's point of view, it enables much more, greater ability to produce work, whatever the size of the firm is. So law firms who have digitalized, the small ones who are niche players, can now deliver the same level of work and competence that the large law firms can do it. And technology, of course, has come down enormously in cost, which has been useful. But I think perhaps more interesting is to look at it from the consumer's point of view or the client's point of view, which is digitalization has gone so far to enable people to do an awful lot of the spade work themselves. So that if they want to do a simple Google search may well give them an answer to a legal problem. The ability to go into a company's house to get basic data about a debtor perhaps, or to do a trademark search. So to some extent, clients have been enabled by digitalization, and perhaps it also means that they give better quality instructions to the lawyers. But as I said, it's freed them up, and I think that's a very good thing. I think also, because people are now perfectly happy to use platforms to communicate with lawyers, perhaps the reluctance to go and see a lawyer has diminished, and therefore people will go online and will do video conferencing. So I think it's very good in that way. I think it levels up the playing field, both from the lawyer's point of view and much more importantly from the consumer's point of view. So as they say, it's a good thing.
Technology is good for us. Excellent. Richard, what's your views on this?
I don't think there's a one-size-fits-all answer, really. I know from friends who work in the commercial world, international arbitration, they're doing hearings at sort of 4 a.m. They don't have to travel halfway around the world. That's up and downsides for them there. But that sort of world works quite well. People coming in from all over the place, the investments there, that all works, runs well. There are other areas, though. I sit as a mental health tribunal judge, and overnight when the pandemic started, accelerated. We went from face-to-face hearings in hospitals to hearings on telephones, and now we're on the cloud video platform. And of course, people with mental health problems may also have problems with a digital hearing. So we have to take account of that. I like those hearings personally, but I have to be careful when I sit as a judge to make sure that people can participate. And I have had experiences of some patients being very nervous about appearing in front of a camera. I don't think it works for jury trials. I'm not actually sold on this idea that you need to be able to look people in the eye, because of course we now have blind jurors, and the idea that you can assess someone just because you can see them, I think, is potentially now outdated. But I do think there needs to be more work done on the effect that seeing a witness on a screen has, and I think that we need to have some work done on what jurors make of it. But I do think it can work. Again, it's investment. We've gone from a system in the Crown Court where we used to have cameras pretty much in front of the jurors. Now they're on a big screen, but a long way away, and you almost need sort of opera glasses to see the screen, which doesn't help. So we need to spend money there. I think it comes down really to what the business is that we're in, and the business that we lawyers are in is justice, and justice must not only be done, it must be seen to be done, and we need to remember that. So as Stuart was mentioning, litigants in person, people who don't have access to technology, all need, if we are going to move forward with this, to be enabled to use the technology and to participate, because what you don't want is somebody having had their case and at the end of it walking away and saying, well, I didn't participate, I couldn't get involved, that was a farce. And that's where the investment needs to be, I think. And we need to do work on looking at what juries make of seeing people on screens. But I think that some good has come from the pandemic. We wouldn't have been in the position we're in if we hadn't had it. This common platform, I suspect, would have still been way down the road. We need to grab the good bits and work on them. So as I said at the start, I'm a fan. We need to knock off the rough edges, and we need to make sure that the platforms we're using are good and accessible.
Thanks, Richard. On the aspect of looking someone in the eye, I'm reminded of the Argentine football player who was sent off, I think, in the semi-final of the 1966 World Cup because the referee saw his intent in his eyes. Anyway, we move on. Let's look finally into the virtual digitized crystal ball that we all have. What does the future hold, both for courts and for individual practitioners? How does everybody take best advantage of digitization? So I guess the initial question is, what do you think are the challenges and priorities for the legal sector in 2022, including the human dimension, the impact of digitization on individuals that Richard briefly mentioned there? Jonathan, what's your take on that?
I think that it's going to produce a huge challenge for people running law firms in the next 12 to 18 months. Practitioners have got used to working in a hybrid fashion, or in many cases totally remotely. And I think it's very difficult to actually ensure that the right glue is there in a firm to enable it to work as a team rather than as practitioners on their own. So I suspect one of the biggest things is going to be making sure that the people come back into the office at least part of the week, and that you build the right sort of camaraderie within a practice. Otherwise, I suspect it may well lead to a number of competent practitioners moving out of established law firms and joining the virtual world by way of joining virtual law firms. And that would be very significant to the way in which practices operate. I think one of the other difficulties is that with remote working is getting the knowledge base transferred to junior lawyers. When you're in the office, you've got the ability to have those occasional spontaneous conversations, which is very difficult to do remotely, even using video the whole time. So from a lawyer's point of view, getting your firm in order and then making the right investment, and as you say, really important to move forward. There's continual need for investment, continual need for lawyers to not just say, well, I've been doing it this way for years using this system, I'm going to stick to it. I think what you will see is greater integration of systems. No longer will people have a separate accounting system and a word processing system, a document management system, a data system, and a video one. You really need one system which is common to the profession and which enables you to transfer data easily, both to other law firms and to clients. So it will require investment, taking good advice, but on a personal basis, on a people's basis, getting the firm to have that common signature is going to be more difficult with people working remotely. Bit of a challenge.
Thanks, Jonathan. Richard, what's your take on this?
The genie's out of the bottle now. It's not going back in, is it? We've got to move forward. But of course, the youngsters coming into the profession will be amazed if they talk to people of your vintage, Robin, and mine. I didn't have a mobile phone when I started at the bar 32 years ago. So we've moved on phenomenally. I think one of my real concerns, and I wrote one of my chair's columns in Council magazine back in 2019 about this, was the effect it has on chambers. Chambers is a collection of individuals who always used to come back into chambers to pick up their work at the end of the day. And there'd always be senior members around that the junior members could go and talk to and pick the brains off. And now, because it's digital, we don't see people coming into chambers. I have a room in chambers and I'm normally in there so that I am around, and I try and get senior members to be in so that they can be seen. And I think we've got to work really hard, particularly at the bar, although I'm sure the same can be said in solicitors' firms, but particularly at the bar, if we want to maintain the ethos of the bar that we've had over many years, we need to make sure people come back into chambers. So we've got to work hard on that. Digitalisation is fabulous. It's the answer to many problems and can work well. But I suppose my real worry at the end of the day is, will it lead to a collapse of the chamber system as we know it if people aren't coming back in? There's a lot to be said for human contact. But I don't want to end on a downbeat note. As I say, I think we grasp this. We take all the good bits, but we make sure that we still have human interaction.
Thanks, Richard. Stuart, how do you see 2022 panning out for how you're involved in the legal sector?
Well, I think, and I think it's been clear from the discussion we've just had, and from all discussions, there's a real battle of ideas going on at the moment, and I think the next 12 to 18 months is going to be crucial. I hope there's more integration. I hope there's more progress on getting A to talk to B. I think that in-person working will bounce back personally, probably not to the same extent as it was pre-pandemic, but I'm not convinced about the sort of work from home revolution, but that's just sort of a personal view. I think there'll be more digital, not less. As Richard said, the genie's out the bottle, but my fear is that it may eventually fall short. I think there is some dynamic thinking in government from what I've seen, particularly around data, the use of data, reforming data protection and things like that, and kind of how, data is ubiquitous in our daily lives. And I think they get that, but going back to the money, once there is a basic digital infrastructure around the courts, will they stop there? I hope they won't, because I think there's more to do, but my fear is that they might. But the only other thing that I think is sort of going to be quite important over the next 12 to 18 months, that I think some organisations have kind of clocked it and others haven't, is that, I think it's the traditional view is to see kind of, you talked about the human element, Robin, is to see sort of human and machine or AI as a kind of a binary, as a one and the other, and a kind of siloed. Whereas I think increasingly the future of digitization is a kind of terrible word, but symbiosis of the two. And I think if we can appreciate that it's kind of how one can feed into the other, then that is I think that's going to mean a much brighter future for the profession in general. Yeah, I hope that's not too meta, but that's kind of my thoughts on the whole thing.
Stuart. Simon, from the tech side, what do you think is top of the agenda for 2022 as far as the legal justice system is concerned?
Sure, thanks, Robin. Well, I mean, just as an initial observation, I think that despite the challenges and obstacles that have been quite rightly aired today, I think we'd probably all agree that digital transformation is critical to the future of legal services. And there's probably never been a better time to build on the lessons of the last 18 months in terms of the technology being able to support agile and flexible working patterns, and of course to just be able to electronically connect, share and distribute information and documentation. So I see digital technology as having the ability to fundamentally transform the delivery of legal services and the day-to-day jobs of many lawyers, and also the workflow and efficiency and service quality of the justice system generally. And of course, that's part of the foundation upon which the HMCTS common platform was built. So I perceive it obviously as being a time of transformation. I can see the legal sector moving increasingly towards cloud and mobile solutions to improve the productivity and efficiency of legal services, but also to reflect the changing nature of how we work and interact commercially, which again has been well aired today in this discussion. So for me, I think building a digital law firm for the future today is going to help legal practitioners preparing for challenges that will come tomorrow. And from a strictly speech recognition point of view, which is obviously my specific interest, I do see that as being a technology that will play a role as a tool in this transformative process.
And Vladimir, taking that speech recognition specifically one stage further, how do you think that you're going to manage this agenda in the digitization of justice?
Thank you, Robin. I believe that the role of speech recognition is a growing one. We have actually seen quite a lot of adoption in many areas already, but we do see that the adoption is expanding by the day pretty much. And it's really a tier one technology. I like to refer to it as my best friend at work because I'm a user myself. And the reason for that is that it's available for me 24/7, 365. Pretty much. I think when it comes to speech recognition as well, we need to remember that there are two strands to it. It is actually widely used as an accessibility tool, for instance, to help in situations when where people might have dyslexia. And equally as well, it is being very welcomed by professionals for productivity purposes. It has many benefits. I think one of the negatives of all these video meetings and calls is that I think personally for me, my documentation requirements have expanded. So there are a lot of emails. I think having these water cooler conversations in the office and what we've been talking about previously, it's quite critical. And some of these interactions, I think you need to interact a bit more internally over email. And that can actually, in some cases, result in burnout. And speech recognition is a tool that can actually reduce burnout because you actually want to have that division of your personal and work life and be able to close the laptop at the end of the working day and spend some time with your family. So I think the benefits are numerous, but most importantly, I think in terms of speech recognition, it's very easy to get started with this. I think some of these technological advancements have been absolutely critical. You no longer need to invest a lot of time to build the profile, so you can get started pretty much in seconds as soon as you've got the system installed. Our value-added partners, such as Crescendo, are very well adept in working with the justice system and can provide organizations with valuable trials. And these trials can produce real empirical results and tangible benefit that is all measurable. Having said all of this, I strongly believe personally that speech recognition obviously is a concept best appreciated through a demonstration. So I look forward to seeing what Simon has prepared for us today.
Vladimir, thank you so much. Well, that brings us to very shortly, the end of this part of the webinar. We touched briefly on aspects of the work-life balance, but there's more to that in this subject to be discussed. We haven't really touched the surface of AI. We haven't mentioned cross-border justice and digitization of that at all. We have used the term symbiosis, which I think is a very good one for the whole idea of technology within the very human and importantly human aspects of the justice system. I think we've concluded that digitization is good. It's been spurred in the legal sector by COVID. We're really looking for commonality, something that works. What we've seen so far is that technology does result in what one might say called leveling up, but we do need to ensure that there's equality across that, taking into consideration aspects of the digital divide that's been mentioned. And as Richard pointed out, a key tenet of this is that justice must be done, but also must be seen to be done. The development of technology and digitization requires leadership across all areas of business, whether that's within a set of chambers, a law firm, or the courts, in order to integrate technology with how the business operates. We're back to that idea of symbiosis. But as lots of people have mentioned, this does require investment. And with every departmental minister at the moment piling the pressure on the cabinet and the treasury for more money, when Rishi wants to rein back, what chance do you actually give the Justice Secretary in securing his existing budget, let alone the additional funds that are needed properly to fulfill the digitization program for justice? And in the meantime, therefore, probably as ever before, I believe it'll be up to individual lawyers, law firms, and chambers to invest in current technology to drive forward the progress enabled by digitization. And one hopes also to invest with the tech industries in research and development, not something that has frequently happened before. So my thanks to Richard Atkins, Jonathan Silverman, Stuart McMillan, Vladimir Teodosiev, and Simon Howard. Please, if you will, stay online now for a demonstration by Simon of the Dragon Legal Anywhere software, but it's goodbye from me.
Thank you, Robin, for that introduction. Let me just share my screen with you, and I'll be very pleased to show you the Dragon Legal Anywhere software in action. So hopefully you can see my screen now. If somebody could just confirm that that's the case, that would be very useful before I make a start.
Absolutely, Simon, can confirm that I can see your screen.
Lovely, thank you, Vladimir. And you're obviously hearing me loud and clear as well.
Yes.
Excellent, excellent. So I'm going to give you a quick demonstration of Dragon Legal Anywhere and give a little bit of a tour of some of the areas of criminal justice where we feel it can really improve productivity and the speed with which documents can be generated. So as you'll see, it's a very, very simple interface. On the left-hand side, we just have a microphone button, which is red at the moment because it's off. I will be left-clicking at it in a second, and then I'll be live and obviously then doing the demonstration. I think probably best thing to do is just get on with it, and then if you have any questions afterwards, please feel free to answer. Okay. Open Dragon Legal presentation. Welcome to speech recognition in the cloud, and more specifically, welcome to the premier and secure cloud-based version of Nuance's flagship Dragon product, Dragon Legal Anywhere. Full stop, new paragraph. Dragon Legal Anywhere is an enterprise strength speech recognition solution with a dedicated legal vocabulary that empowers legal and justice professionals to create high quality documentation, all by voice and saving time and money, full stop. New paragraph. Dragon Legal Anywhere has many high-end, customization features to ensure that users can create documentation in the most productive and efficient way possible, full stop. New paragraph. For example, use auto texts to add blocks of standard text to your documents, New document. Insert Dragon Legal features. New paragraph. Carter case law. New paragraph. Insert stop and search grounds. New paragraph. By using the power of Dragon Legal Anywhere's customized voice command feature, together with the opportunity to add further customized words to include localized phrases and acronyms, there really is no quicker and easier way to assemble your documents and emails, full stop. New paragraph. Here are a few examples, Insert charge sheet. Next field, 15/68. Next field, caps on, reckless driving and drink driving. Next field, caps off, M20, near Flyford services. Next field, Gary Peterson. Next field, mail. Next field, 53, Stringers Avenue, Flyford Vale, FY65 7GT. Next field, unknown. Next field, 07989 997 885. Next field, offender accused of driving recklessly and without regard to the safety of others, full stop. New line, collided with lorry on busy M20 and caused multiple collision involving 26 vehicles, full stop. New line, offender failed breathalyzer test on site, open bracket, 165 milligrams per 100 milliliters, close bracket, full stop. New line, at least one person has been critically injured as a result of the RTA, full stop. Next field, caps on, drink driving, caps off, driving whilst under the influence of alcohol, full stop. New line, caps on, dangerous driving, caps off, open quote, falls far below what would be expected of competent and careful driving, close quote, full stop. Open client letter. Next field, caps on, appeal to reduce conviction, caps off. Next field, Mr. Peterson. Next field, we have received instructions from you regarding your recent conviction and sentence for caps on, reckless driving and drink driving, caps off, in the Crown Court on 22/04/2021, full stop. New paragraph. If I understand correctly, it is your wish to appeal against the length of sentence, being a period of 8 years, imposed by the learned judge, comma, Justice Makepeace, full stop. New paragraph. We will need to organise a conference with counsel to discuss the merits of your case, but would surmise that this matter should be referred to the Royal Courts of Justice, comma, Criminal Division in London, full stop. New paragraph. Once we have had an opportunity to consult with counsel, comma, I will revert to you with the intended plan of action, full stop. New paragraph. Many thanks indeed, comma. Open Outlook. New mail. Keith Jones. Subject field. Client Gary Peterson. Start message. Dear Keith, comma, new line. I hope you are well, full stop. New line. Our firm would like to engage you with regard to providing advice on the likelihood of being able to successfully appeal for a reduction in our client's sentence for caps on reckless driving and drink driving offences, caps off, full stop. New line. I will organise for a full brief to be sent to your chambers, but, comma, in the meantime, comma, could you kindly propose some dates and times for us to discuss this matter via conference call in the next 7/10 days, full stop. New line. Many thanks and look forward to hearing from you, full stop. New line. New line. Email signature. Close email. Insert criminal pleading document. Next field. Firm address. Next field. Royal Court Criminal Division. Next field. Mr. Gary Peterson. Next field. DJ /123-879/2020. Next field. All caps on. Reduction of custodial sentence. All caps off. Next field. That appellant applies for a reduction in his sentence of 8 years for caps on reckless driving and drink driving offences, caps off, full stop. We believe that the length of sentence is disproportionate to the offences committed, full stop. Next field. 18/06/2021. Next field. Firm name. Next field. Firm name. Insert release request. Next field. Flyford Prison, comma, Criminal Row, comma, Flyford, FT23 60H. Next field. Gary Peterson, hyphen, prison number 38160. Next field. Flyford Prison. Next field. Mr. Peterson is suffering from chronic depression and mental anxiety following news that his father is suffering from severe COVID-19 symptoms. He fears that he may not see his father again given the severity of his condition. Next field. Gary Peterson. Next field. Clinical depression and anxiety attacks. Next field. Gary Peterson. Next field. Robert McGovern. New document. Many thanks for watching this demonstration of Dragon Legal Anywhere, full stop. Hopefully, this presentation will have demonstrated to you the variety and versatility of the use cases available to many sectors of the criminal justice system, full stop. New paragraph. By the way, the above claim by Gary Peterson was rejected, and the court decided that instead he was a strong, open quote, flight risk, close quote. So his sentence was actually increased by 6 months as a result. Smiley face, exclamation mark, microphone off. Okay, so that gives you a quick guided tour, hopefully, of some of the things that you can achieve with Dragon in creating your documents. The ability to bring in standard pieces of text, to jump between fields in templates, really makes it very, very productive and very efficient, and will ultimately save you a great deal of time. Let me just stop sharing now, and if there are any questions, we'd be delighted to answer them.
Fantastic. Thank you, Simon, for this presentation, which is all-encompassing and shows how flexible the technology has many use cases.
No problem. That's a pleasure.
Just mindful of the time, I do have 2 quick questions. So I'll start with the first one. Is it time for barristers and staff to have a level of technology training skills as part of CPD, of the continued professional development each year? Is it now to the skills of the job rather than something that the IT or someone else should do on their behalf?
I'm sorry, Vladimir, I've lost myself on the screen. Could you just quickly repeat that for me?
Yeah, basically the question in a nutshell is that what's required for barristers and staff to have a technological component within their continuous professional development area? And is it now core skills to be technologically proficient rather than something else that should be done by IT or another profession?
Sorry, yeah, it's a line. It keeps breaking up. I think if I get the gist of your question, I think it was to do with the ease of implementation. Is that correct?
More or less, yeah. I can probably answer the question. I think nowadays, with all these advances of technology, I think many of the solutions out are intuitive. So as you have just speech, kind of really easy to get. So I think for probably more of the advanced kind of use case, answer speech recognition, and all to text functionality, and that to have some sort of training. But I don't think necessarily that it's kind of really required. Some of the vendors out there, they actually have these optional programs and trials to help professionals. So I think it's very easy to start it. And I think links well to the next question in terms of filing the development and implementing the technology. So is that something that I think we briefly touched upon this on the actual discussion, but how does it work with trials provided by your organization?
Sorry, it's just the line's actually breaking up all the time. Were you asking about trials and how we go about implementing trials? Yep. Ah, fantastic. Good. I got the gist of it. So we run 30-day free trials for organizations. It's very, very straightforward. The software is incredibly easy to deploy. It uses what we call one-click technology. So you literally just drop the application onto the relevant devices, and you're able to then trial the software for 30 days. We will also give you an overview of the product before you start, just so you're familiar with the interface and how to use the various features. And one of the most powerful parts of the 30-day trial is actually that Dragon Legal Anywhere has an analysis module built into it, which means that at the end of that period, as an organization, you're then able to assess the performance of the software on an individual basis. So you can see how much work has been produced, how quickly it's been produced, what kind of time savings are involved, and also, equally importantly, what kind of savings are involved as a consequence of being able to generate your documentation more rapidly and more efficiently. So we're absolutely delighted to be able to offer that complete service to you for 30 days so that you really can try it in action first and foremost before you decide whether or not you want to move forward with the software within your organization.
Can you hear me better now?
Not really, no. It's a very poor line, but keep trying, Vladimir.
Yeah. That concludes the session today, so let's give it a close.
Okay.
And, yeah.
Okay, well, thanks very much for your time, and we obviously hope you enjoyed seeing the software in action, and please feel free to make contact with us if you're interested in exploring a trial of the software for your organization. Thank you very much.